reiterate what we said in the application for stay, that the circumstances of this case are mitigation in themselves. An applicant who comes to court for ex parte orders which are not prosecuted, and for the avoidance of doubt, we are not seeking to appeal the ex parte order of 23rd of October 2021. We are seeking to appeal your Lordship's order of October 2023. And if your Lordship is asking where we have been for 2 years since the ex parte order, we have been waiting for the applicant to set the matter for hearing. It's not our responsibility. And it is not usual to appeal against ex parte orders because you expect there will be an inter parte hearing. And I want to remind, itself a mitigation. It is a matter of fact that the defendant's house was bombed. He avers on oath that the prime suspect is Governor Mutua, the applicant, or is it CS Mutua now? Governor CS. And just to show how serious that is, there is an application before you for joining the Inspector General who has not done anything. And I'm asking the court to consider itself. What is he supposed to do? Forget that his house was bombed? Not talk about it? Not press the police? What is he expected to do? The Governor CS's knee is on his neck. I might also say he's been busy trying to reconstruct, to provide his family with a home. That's the work he was given by the criminals who bombed his house, of which the prime suspect is the applicant before you. And whereas the defendant respects this court, it is our position that if indeed Governor Mutua has Governor CS has a reputation to protect, he should have set his case for hearing. Clearly, this is an abuse of the court process. A gag order on a person who has been wronged. With a counsel who articulates, as well as my learned colleague, this case would have ended ages, but all the efforts for 3 years are just for gag orders. That in itself is mitigation, and I'm saying, indeed, this matter is technical in the sense that even this court, I am sure, would hesitate to tell an aged person not to cry for help. And that is the situation in this court. Finally, I want to say this. That application was heard by way of submissions, inter partes. This court has not issued a ruling on it. Are we going to blame that on the defendant?
That is one of 26.
Yeah, submissions have been exchanged. And I am sure that if the court were to give a ruling looking at the affidavits, looking at the annexures, which actually show point by point why the applicant says what he does, I am sure this court would not be party to suppressing the truth. We leave it to the court. We shall still go ahead and file a formal application for leave to appeal, tolerate, and then before objecting. But I have this to say, that when an applicant, plaintiff, files a case, gets ex parte orders, does not set a date for hearing 3 years later, and is just pushing for the enjoyment of the ex parte orders, which in this case are gag orders, it is indeed a demonstration of abuse of the process of the court, and which leads to the statement, if the applicant, because this case is not more about the honor of the court, what the applicant is pushing is protecting his reputation, and my colleague has said that. If he genuinely feels he has a reputation to protect, he would have set the case for hearing. That's what I'm saying. And you don't file a case and then say, even you, the defendant, could have set a case for hearing. No, no, no. The responsibility, primary responsibility, to get up on the case is on the person who's there.
No communication was made to us along that line. Peradventure, Your Lordship, and in the event that we would be gracious enough to say, oh, you can have that, which would save you, Your Lordship, the time, the trouble of what we have gone, and judicial time is so precious now we have expended. B, Your Lordship, this defendant did not care to file an affidavit of mitigation and or explication of his position post your ruling. Post your ruling. And then C, Your Lordship, in the result and in the circumstances, the sentencing has to go on because that's what the law dictates that should follow when there is express and contumacious conduct amounting to contempt of court that has been occurred. Until and unless the lifting or the stay or the vacating of the order of the defendant being held in contempt of court has been issued, either by yourself or the Court of Appeal, the defendant still remains in contempt of court. Your Lordship, in light of the fact that there has been a dearth of evidence, the lack of explication by this defendant why sentencing should not go on, I'm afraid, Your Lordship, he must be sentenced. And then, Your Lordship, while the law is taking its course, he can activate you. And Your Lordship, you have there to be persons who are incarcerated for reason A or B, or they are seeking leave to appeal. Nothing special about this defendant warrants the suspension of this case. No communication was made to us along that line. Peradventure, Your Lordship, and in the event that we would be gracious enough to say, oh, you can have that, which would save you, Your Lordship, the time, the trouble of what we have gone, and judicial time is so precious now we have expended. B, Your Lordship, this defendant did not care to file an affidavit of mitigation and or explication of his position post your ruling. Post your ruling. And then C, Your Lordship, in the result and in the circumstances, the sentencing has to go on because that's what the law dictates that should follow when there is express and contumacious conduct amounting to contempt of court that has been occurred. Until and unless the lifting or the stay or the vacating of the order of the defendant being held in contempt of court has been issued, either by yourself or the Court of Appeal, the defendant still remains in contempt of court. Your Lordship, in light of the fact that there has been a dearth of evidence, the lack of explication by this defendant why sentencing should not go on, I'm afraid, Your Lordship, he must be sentenced. And then, Your Lordship, while the law is taking its course, he can activate you. And Your Lordship, you have there to be persons who are incarcerated for reason A or B, or they are seeking leave to appeal. Nothing special about this defendant warrants the suspension of this case.
What about those oppressed that he speaks on behalf of? And I say this noting, my Lord, that this court is a temple of justice. But justice must be tempered with mercy. And I plead for this court's mercy. We need to allow this man to continue doing what he does. The court must look at this man and consider his contributions to our society. My Lord, in 2007, Boniface Mwangi, while working as a journalist at the Standard newspaper, was sent to cover the post-election rally. He witnessed horrific images of death, mutilation, images of death, mutilation, and bloodshed. And when this country moved on, as it always does, Boniface Mwangi single-handedly chose to publish images to not only shock the conscience of the nation, but to remind this country the journey that we have traveled. For his work, he's a two-time winner of the CNN Journalist of the Year. Winner of the CNN Journalist of the Year. He's the youngest recipient of the Prince Claus Award. Prince Claus Award.
Prince Claus.
Yes, this is issued by the nation of the Netherlands. His work has been recognized globally. For the important place that he occupies in our society, my Lord. Beyond that, Boniface Mwangi brought to the attention of the nation that Kenyans were experiencing extrajudicial killings and were being thrown into the river Yala.